All right. Okay. Welcome everyone. I'd like to call the January 2nd, 2024 meeting of the Medical Record Requests and Record Fee Working Group to order. Happy New Year, everyone. Glad to see everyone back as we head towards the finish line on this group. Rep. Conley, do you have anything that you'd like to say?
Happy New Year, and I look forward to our discussion today. I believe we are going to talk about the workers' comp statute, which is a new topic for this group.
All right. Thank you. First item then will be the approval of the minutes of the December 12th, 2023 meeting. If I could have a motion.
So moved.
Second.
Second.
Any discussion, corrections or changes? All right, seeing none, we'll proceed to vote. All in favor, say aye.
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 Opposed? Motion carries. I don't think we'll take the full 2 hours today, but we did want to have a discussion on the workers' compensation, excuse me, statute, which is 31294F. And that is a statute that deals with records in workers' compensation cases, particularly subsection B states, and I'll read it because it's rather short, that all medical records concerning any injury of an employee sustained in the course of his employment shall be furnished within 30 days after the completion of the reports at the same time and in the same manner to the employer and the employee or his attorney. Obviously, we don't have the cost issue on the workers' compensation side, but in looking at this, I think that the 30 days after the completion of the reports is rather broad when you think about it. So I just want to get everyone's thoughts on that and if it should be tightened up. There's no penalty provision as it's worded at the moment for any report that is not done within 30 days after the completion of the report. But I'd be curious to hear what everybody's thoughts on that are. I mean, I don't think that at least from the provider or the third-party provider standpoint, there's necessarily any issues in complying with the 30 days after the completion, but completion is where I think we get into the delay problem on the workers' compensation side. And if the record is, delayed a month, 2 months, and then you've got an additional 30 days on top of that for distribution of the report, I mean, it can really, to me, get out of control rather quickly. And I've seen it in my own practice. And we've had some medical groups that are notorious for taking quite some time. And also, how are we really going to know when the report was actually completed to start that 30-day clock? So I just throw that all out as topics of discussion as we go forward with this issue today. And I see that Jennifer Cox has her hand raised, so I'll let her go first.
Thanks, Representative Quinn. Happy New Year, everyone. I wanted to just do a level set on what we're discussing. I pulled up the statute, which of course we probably all looked at before. My understanding has always been that these are the medical reports that are filed by a provider in a workers' compensation case, not medical records, which are two different things. So that's a important level set issue. I have no doubt, I do not question the concerns that Representative Quinn mentioned about how it can slow the process and how it can drag on. But a medical report under this statute is not the medical record; it's the assessment portion. But related to that and related to medical records as opposed to medical reports, I just want to clarify, a lot of providers have been trained, I think appropriately, not to release records that are in process. because they are not final. They might not have the right labs back. They might not have the right information. And that is a natural slowdown to a lot of things. And it also might affect when a report is completed. So I don't have an opinion on how to fix the problems that Representative Quinn mentioned, but I do want to clarify this statute is not the same as the medical record statute. This is about those providers who take or have to take workers' compensation as the insurance payment and their obligation to complete a report. Thank you.
Thank you. Mike D'Amico.
So I would make a similar comment that the statute, when I read it, seems to apply to a report that's the conclusion of an examination that was required either by the employer or workers' comp commissioner. At least that's the way I'm reading it anyways. And I hear you that the medical report being due 30 days after completion is really very ambiguous. And my suggestion would be that it be geared towards the date of the exam. And if, these are physicians who are willing, if I'm understanding the process correctly, I'm not handling workers' comp anymore, but I did some time ago. But if I understand the process correctly, these are doctors that have made it known that they're willing to examine employees at the request of an employer or at the request of an administrative law judge. And there's probably some procedures that they can put in place to make sure that they're able to deliver a report within 30 days of the date of the exam. Now, there may be some bona fide reasons that needs to be delayed. If there's an MRI that needs to be conducted, or blood work that needs to be conducted, or pulmonology that needs to be conducted, although it's not, unless you tell me to the contrary, Mike and Chris, I don't know that it's that common that a doctor doing an exam like that would actually request that a particular test be performed, but perhaps they would. Generally that's a treating doctor, but my thought would be it should be geared towards the date of the exam. It seems to be the only way that you can do that, other than saying that the 30 days begins to run so many days after the exam. So if you allow them, say, 7 days to complete a report, then the 30 days would start ticking after that. But to leave it up in the air, such that you don't really know when the report is completed and there's no time constraint on the completion of the report, that, to me, that's a recipe for delay.
Thanks, Mike. Kyle Probst.
Thank you, Representative Quinn. I would just like to state that I agree with Jennifer and Michael's statement regarding the distinction between the report and the records and how they're handled here. And I just wanted to do my own level set, bringing the third party record retrieval company and record reproduction companies perspective here. We don't release records unless we are requested to release a record. So absent a request by either the provider or by someone who needs the record, say the attorneys or the employers or the insurers, we wouldn't disclose it. So I just wanted to make sure that we include that element in there. If there's to be, I apologize. If there's to be any burden, or I think there was a penalty at one point for not disclosing the reports within a certain time frame. If we don't get a request from the provider to disclose it, or a request from the insurer, the employer, the attorney to disclose it, we wouldn't know otherwise that it's ready and done and ready to be disclosed.
Thank you. Rep Conley.
Thank you, Rep Quinn. A couple things. One of the things that we as a General Assembly try to do is when we open statute, when we look at statutes and we realize that we have a gender nonconformity, is to make them gender neutral. So I'd like to point that out, that we can change his record to their record, because women have been working for years, so we should look at them too. But a couple things about the meat of the statute, not just the gender neutrality of the statute. I would like to ask that it be considered to have a penalty within the administrative law judge's ability. They have abilities in other sections of the statute to look at if something is just an error or misconduct, And I think our administrative law judges are appropriate to apply the penalty only when it's necessary, as they do in the other sections of the statute. They do not generally, they're very rare, I've seen, to apply penalties. And that would give the ability, if a record is stopping someone's treatment, that would give the administrative law judge an ability to go in there and make a correction. I think the system is set up with hearings, and the administrative law judge had the ability and the knowledge to do that. I've seen, I know that the treating physicians, also these records or the reports come from them as well. And I've seen some things that happen, which is not an unreasonable delay. It would be a delay if an assistant saw someone and they're waiting on the physician to sign off on the report. I think some of us have seen the draft reports come out, and then you see when the physician signs off on the report, the recommendation could be different. So it is important to have your final report as opposed to a draft. I think we've all seen where lefts and rights get mixed up. So that's why you do have the final report, so that you're not recommending, the wrong treatment on the wrong body part just due to a dictation error, because they, like a lot of folks, most of our physicians are dictating, and then they get the draft report from the dictation company, and then they do have to edit it in case there is an error, because we wouldn't want people to have the wrong medical treatment due to the draft. So I think the final report is that's what is referring to. If folks are newer to that language, I think it's important. But I do think that we do have an issue in when the 30 days after the request was made, received, and you still don't have the record. I think it's really delaying to two issues. First of all, it's stopping the person from getting their treatment. Without the report, the insurance company can't approve the treatment, or the record, even if the insurance company wishes to approve the treatment quickly, they just can't approve it, and the person's stuck without their medical treatment. The other issue has to do with overpayments and underpayments because of folks' work status. So if the doctor is changing the work status to making someone able to work, light duty or full duty, or making someone unable to work, if you can't get the record or report, the person's kind of stuck in limbo for a while. So most of the doctors and most of the physicians are very good about getting those quickly. But when we have that issue, and there's a few practices that are known to have that issue more than others, I think putting the penalty within the administrative law judges will hopefully start to solve these problems. When people are not getting paid because their work status changes, as noted, that's hard on their families. And also, if people are to return to work and still getting paid, and the insurance companies can't process that paperwork, that does result in overpayment. So it's a problem in the system that we do need to get fixed. I don't think they need longer than 30 days, but I think if we threw some teeth in the statute, we would solve some problems.
Thank you, Rep. Conley. Marie Gallo Hall.
Yes, good morning, everyone. I just want to comment on something that Kyle said about not sending out records unless there's an actual request. The way the current statute is written, there is no need for a request to get updated records as we go along in a case. They are supposed to be automatically sent out within 30 days. And I know I'm not going to comment on what the appropriate trigger for that 30 days is. I'll leave that to this group. But it does concern me to hear that records aren't being sent out automatically, because that's what the statute requires, that they're sent out automatically to both the claimant and the respondents in the same manner and at the same time. So that concerned me that when I heard that.
Okay, thank you. Kyle?
Yeah, Representative Quinn, I'd just like to address Marie's statement and concern. Marie, I just want to be clear that I was commenting on behalf of the third-party businesses that produce the records, not the providers. So if the provider has a report done and comes to us and says, I would like you to send this report to, ABC law firm, we will do so. What I was trying to convey there is that we are not medical providers. We're the third-party release of information vendor. So we're not just we wouldn't know, hey, this report is done, just send it out the door without somebody asking us to do so. Just so we're clear our role in that process.
Okay. Thank you, Kyle. Kyle, question for you. Do you, in your coding or procedures, do you draw any distinction between a workers' compensation case that's ongoing and the need for the reports to be distributed in a timely fashion versus personal injury cases?
We have a indexing number because many states, as the spreadsheet that I believe Michael D'Amico and Rick Silver produced from the American Trial Lawyers Association, there's a distinction between workers' comp rates and personal injury or med mal rates or just other third-party requests. So we do it at a base level of just understanding the fee application, but as far as knowing if there would be ongoing requests that would be tied back to the original request, no, we do not. So we do distinguish them, but only to a degree, if that makes sense.
Okay. Can your systems be set up in workers' compensation cases that they are in compliance with the statute as presently worded, which would mean as soon as you get the report from the doctor, it automatically goes out to the attorney and or claimant on file?
I don't know an answer to that off the top of my head. My assumption would be that we could probably do some programming. We would have to develop it. It's not set up that we just flip a switch right now and we'd be able to do that. But again, I have concerns with us as a third party just releasing a record without at least the provider asking us to go ahead and release this record. Meaning the provider should come to us and say, this report is done. It's okay to release under statute. I believe you said it was like statute 31294. And then we would release it. I don't know that I'd feel comfortable with us just releasing a record because it appears in the EHR or a report because it appears in the EHR.
Well, I mean, that's how the system is set up at the moment, is that is supposed to be occurring. And, you know, I don't know if this is going to become more problematic as more medical providers turn to third-party vendors because it's a more efficient and cost-effective way for them to handle their medical reports and medical records. So, Jennifer.
Thank you. A couple clarifications since I do work on the provider side. I know Kyle's saying that he's working on the third-party record side. So part of the challenge with both reports and records in workers' compensation is it still has to be within the workers' compensation claim. And I know we all agree that there's a certain amount of information that is either historical or put into issue, as we lawyers like to say, that might be not specific to the exact injury. But there are also times, for example, when you're seeing the orthopedic surgeon you've seen for years, let's say you injured your hand in a non-work related injury 5 years ago, and then you have a foot injury at work, and the foot injury is the one that's relative to the workers' compensation claim. It's very difficult to have an automated system where we're not supposed to send things about the hand that is not related to the workers' compensation injury and only about the foot and have it be automated and not miss something. So there is still a human factor in what is collected and sent with the workers' compensation information. Most providers, not all, but most providers treat workers' compensation as a regular payer because it's allowed under HIPAA to do it that way. And it creates an easier flow. It's also why you might realize as a consumer, for those of you who are based in Connecticut, if you go to the doctor, and pretty much anybody that deals with musculoskeletal type issues, they're going to ask you every single time now, which they already do, is this a work-related injury? Even if you've been there, 10 times in a row, because they need to know if that encounter is meant to be treated as workers' compensation. That is a challenge that's going to continue. So automation has a privacy issue. Another thing about what Representative Conley said, I feel your pain as a former litigator on trying to get the records timely. I'm concerned that let's be careful what we ask for situation, that what will happen is those final reports will end up being far less robust than they are right now. Maybe they meet the statutory obligation, but I'm not sure you're going to get the same quality of information. I'm also curious, I don't know how big a problem it is. It seems like Representative Conley indicated most providers are okay with this. I mean, that is to say they stay in the lane. If we're going to change a statute because there are some bad apples, that seems like Perhaps there are better ways to deal with that. Maybe Workers' Compensation Commission could have more reminders about how it works if you're taking comp as the provider. And one last thing, and then I'll be quiet again. When you treat the Workers' Compensation folks as a payer, like most providers do, that they have similar prior authorization type issues with reports and fundamental next setting of care choices as they do with a lot of other payers. The biggest problem is actually Medicare Advantage, where the prior authorization reports and information is a lot. So it isn't that there's this one stream of information, one payer, in this case workers' comp, that isn't getting service. There's a pipeline, and as I've mentioned before, if you expedite everything, you expedite nothing. So there's a lot that has to happen for providers so that everyone gets their insurer to authorize the next type of care or a procedure. But that's true across the board for commercial payers, for Medicare Advantage, and for workers' comp. So just want to be careful reprioritizing, totally legitimate, but you need to know it's going to knock somebody else out of priority.
All right, thank you. Rep. O'Day.
Good morning, everyone. I'm sorry if I missed, I got on about 5 minutes late, but have we gone over the proposed fees? Are we waiting to do that later?
No, Tom, we're going to deal strictly with the workers' comp statute today, and at the next meeting, we're going to deal with the fees. Rep. Conley.
To respond to what Jennifer Cox mentioned, I think the bigger issue that's been raised by the Bar Association on the executive committee, and this is the claimants and the respondents' lawyers, is that our bad apples seem to be the larger hospitals. So it is developing to be an issue. I know Kyle deals with one of the hospital associations that he works with is Yale, and as our larger groups are getting more and more smaller providers, their requests are having to go through the main hospital instead of the provider offices. So I did see, and I thought of Kyle this morning when I went through my mail. One of the requests that we asked for in my practice, we asked for the request on, because I know we often talk about requests taking a while, asked for the request on 12/27. The MRO report shows that it was received on 12/28, and the MRO letter received was sent on 12/29. So when it works, pretty good. And the report, the record, the assessment which was needed was received this morning. So request on 12/27. We had a holiday weekend. Got what I needed in. Just took a few days. When it works fine. But when it's not working, you got someone who's stuck in limbo. Again, on both the claimant side, trying to get medical treatment and payments, and on the insurance industry side, trying to make sure that there's no overpayments, that the appropriate medical treatment is being done and the appropriate payments are paid at the same time. And I'm not picking on Yale, because actually Yale is not the biggest problem child, but we are seeing as more of the smaller practices are coming into the larger practices, because that seems to be the business model of today's medicine. We are seeing more issues. There isn't our biggest problem, I would say, that's been discussed in the workers' compensation executive committee is not Yale, it's not Harvard Hospital, it's a different large organization. And that's why I think if we had the administrative law judges have some teeth, they could deal with if someone's showing up multiple times, the commission itself could deal with the problem without one attorney or multiple attorneys calling and dealing with it. The actual commission could have the authority to deal with the problem, which is what a lot of folks have been asking for a couple of years, is that, hey, we know this is a problem. We know they're delaying treatment, they're delaying payments, or they're on the insurance side, they're causing overpayments. We need something to get in to have the authority to deal with that problem and help it.
So, what is everybody's thought? Is 30 days from, well, I would say, at 30 days from the visit, is that a sufficient amount of time? And in most cases, if it is, do we then set up some sort of an extension of time process? Because, there may be circumstances where the report cannot be generated within 30 days of the visit. And I understand that. But it just seems that the way that it's currently worded, the 30 days is almost meaningless, because you just don't know when the report was actually completed. Lane Gakos.
Hi, good morning, everyone. Happy New Year. My name is Lane Gakos. I don't know that I know a lot of you. I'm the executive director of the State Medical Society. I missed a couple of the first meetings. They had a conflict with our schedule. I want to just point out that we're missing a pretty important voice on this call today. Sue Schaffman, who's the executive director of the Connecticut Orthopedic Society. Obviously, when we're talking about workers' comp, we're talking about a lot of orthopedic offices. She cannot be on today. She had a family emergency. So before this group comes to any conclusion, I would really hope that we have the opportunity to float some of these issues by her to get the perspective from the independent and the smaller orthopedic offices. I think it's an important voice in this conversation. And as I said, I'm happy to facilitate that with her, but I'm hoping that she gets an opportunity to weigh in on some of this very important discussion.
Okay, thank you. Mike D'Amico.
I would imagine, as you suggested, there are times where there may be a reason why 30 days isn't appropriate, but as Rep. Conley had mentioned, maybe the thing to do is to allow the commissioner authority to extend that 30 days for good cause shown, and having some, requirements as to what good cause would be, so that it's not abused. It could be probably built into a penalty provision that Rep. Conley was mentioning. That would be my suggestion. But I do think you need a definitive timeline where the 30 days starts to tick, and 30 days from the visit seems appropriate to me.
Thank you. Jennifer Cox.
So I'm just curious how that would work, what Mike just suggested. So the provider's a third party to this, right? The provider is providing care, and the payer happens to be workers' comp. And so you're suggesting we create a level where the physician or hospital or provider has to go to the workers' comp commission unrepresented and make a plea to extend the time. That just sounds like a lot of red tape for something that seems like we haven't tried lesser ideas on how to solve this, or maybe you have tried lesser ideas on how to solve this. You're going to get reports that say the patient has not reached maximum potential. The patient is not, I cannot rate it today. You're not going to solve the problem you want to solve as quickly as you think. And again, you're prioritizing something over other things. Just want to be clear, that's going to deprioritize something else. So I don't know that the provider being hauled in front of the workers' comp commission is the best thing. Maybe you want to ban them for workers' comp, in which case you'll have no provider to provide that. So that I'm not sure where that ends, but I don't know that that's the answer.
Well, I mean, clearly someone envisioned the 30 days, and for whatever reason it was written as 30 days from the completion of the report, as opposed to 30 days from the visit. I don't, if the report is done, I don't know why it should take more than 30 minutes for the report to be sent out. So, not knowing the legislative history as to how we came up with 30 days after the completion of the report, it just seems like it's set no deadline, except once you finish it, whenever that is, you get 30 days to disseminate it, which seems like way too much time if the report is actually completed. So, I agree with Mike D'Amico that I think it should be 30 days from the visit. And then really the sub question becomes, if there's going to be some sort of a penalty, who should it be assessed against? If the medical provider, the doctor's office, has completed the report within the 30 days and sent it to the third party records outfit that they have contracted with and then it doesn't get out within the 30 days, is it the fault of the doctor's office, or is it a fault of the medical provider, the third party medical records provider, or somewhere in between? And I guess that would be a question I would have too for Kyle. Once you get a medical report, do you need to step away?
I will wait. Thank you.
Okay. Once you get the medical report, I mean, would it take you an additional 30 days to disseminate that report?
It should not take an additional 30 days. I would think once we have the report and the request to release it, I would think that would be fairly expedited, just like Representative Conley mentioned with her recent record request that she received records. I would hope that it would be much faster than that. My concern is there are records that are put into EHRs not even on a daily basis, on a minute by minute basis. And we don't have a way as a third party vendor to know when an EHR for patient John Doe is updated and that we have a record to release, because we aren't the medical provider, we're the third party. So we're not continuously monitoring the updated records in the EHR. We would have to receive a request, presumably from, and I understand the statute places the burden on the provider, so it would be up to the examining doctor to tell us, this is a workers' comp matter, I finished my report, please release it. And then at that point, we'd be able to release that. We should be able to do it within a couple days.
Okay. What I'm concerned about is if we did change it to, I mean, the way that it's worded at the moment, it actually doesn't necessarily put the burden on either the doctor's office or the third party medical provider. It just says that report needs to get out within 30 days of it being completed. I lost my train of thought. So, if we changed it to 30 days from the date of the examination, and the doctor's office gets it to the third party records company on day 29, the doctor's office has in theory complied, but is it fair to expect that the third party medical provider could then get it out within that day? And it sounded like what Kyle was saying is that it can be done reasonably quickly, but I don't know if that's too quick. I mean, I'm wondering if some sort of an additional buffer should be put in to protect the third party medical providers. Since you can only hand out what you have. And if the doctor's office is taking more time to get that to you, I mean, I don't think it's fair that you should bear the penalty for that. But I guess what I'm trying to get out of you is a sense of what is a reasonable amount of time once you have the record or the report.
I think I would have to talk to our team to see the record priorities that we have in Connecticut that are already prioritized, such as like continuing care. And I realize that this could fall into a form of continuing care, but without committing to a specific number of days right now, I'd like to talk to them and see the priorities we have already on record requests, like Jennifer mentioned.
Okay. All right. Thank you. Elizabeth McElhinney.
Thank you. I just wanted to kind of build off what you had mentioned, Representative Quinn. As Kyle had stated, we would very much as third party, release of information providers want to get this out as soon as possible. However, there are unfortunately some instances when we do get those, requests from our partner facilities quite late. So having a reasonable amount of time afterwards to be able to turn that around would be great. Obviously, in a perfect world, we would get those, reports dictated and to us, the request that is to us in a timely fashion. So we could turn that around. And I would also need to go back to our member companies to see what would be a reasonable number of days. Although I do understand that, as that report had taken a number of, up to 30 days to potentially get to us, we would want to turn that around for continuity of care, and to make sure that the patient could receive, their appropriate treatment.
Okay. Elizabeth, in the contracts that you enter into with doctors' offices to provide their record handling services, are there time limits that are put in those contracts? I mean, does the doctor's office say to you, yeah, we want you to do this, but, we want the reports to get out within X amount of time? Or does the contract say anything to the extent of, okay, doctor's office, you've contracted with us, you need to get us the records within X amount of time? Anything like that in these types of contracts? And if so, is that something that's normal or standard, or just depends on the doctor's office?
It depends upon the practice or the organization.
Okay. All right. Thank you. Mike D'Amico.
So I hear what Jennifer had mentioned, and it's an interesting point. It seems to me, and I'm just thinking out loud, because this is something that I'm kind of digesting today as we go along, but it seems like there's different groups, if you will, of different buckets of providers that are providing reports. One bucket is the employer requested examination. The other bucket's the workers' comp requested examination. And it seems like the last bucket is the treating folks. With respect to the employer requested exam, to answer your question, Mike, it seems like the appropriate person to be penalized if the employer's exam report isn't received in time is the employer. And if the report isn't generated timely by the workers' comp commissioner's enlisted doctor, then whoever is paying that doctor for the exam, maybe there's a reduction in the fee. I mean, the doctor's not doing it for free. The employee's not paying for it, but that doctor is getting paid somehow, I would imagine. I don't know. They're not doing it for free. You're probably more familiar with that than I am. Maybe there's a reduction in their fee. They're obviously making themselves available to do that, and I'm sure that their intent is to generate some additional revenue for their practice in doing that. So if they're willing to do that, then there should be some provision in there to penalize them if they're not delivering the reports in time that they're essentially saying that they'd be willing to do when they agree to do it. The treating doctors is more complicated. And I'm not sure how best to deal with that because the employee is not paying for that. So I'm not exactly sure how best to deal with that. I think that requires some more brain power than I think I can give it on the spot. But it does seem like we're dealing with different buckets of providers, and it's easier to provide some kind of penalty incentive for, it sounds like two of those buckets. The third bucket would require a little bit more thought.
Yeah, and it's the treating physician bucket is where the majority of the problems arise. The respondent's medical exam and the commissioner's medical exams, those reports typically come out within about 2 weeks. So they're generally less of a problem. And I Rep. Conley, you'd agree with me on that, correct? Yeah.
Yeah, I would. And the commissioners, when we've had issues with the CMEs, their staff is because they set up the appointments, is very good at trying to get them timely. And I would say the respondents are usually trying to solve a problem, is why they asked for an exam. So they have a desire to get their report quickly to get to the problem they're looking to solve. It tends to be when the treaters' reports are delayed that either the claimant isn't receiving treatment or the insurance company can't approve the next step of treatment, and that's where the delays are in the continuity of care.
Yeah. Okay. Other thoughts on this? I mean, I fine with the third-party providers taking some time to think about timelines and things like that. But and I realize that this is a narrow issue that certainly doesn't affect most of the people in this working group. But you know, in thinking in general about medical reports and medical records, you know, I think that this has relevance to the discussion, though more minor in comparison to the issues that folks who are on the plaintiff or defendant side of a personal injury or medical malpractice matter are concerned with. Any other thoughts or concern? Go ahead, Rep. Conley.
I know the third-party providers, we'd ask them to get back to us with what is a reasonable amount of time. Also, if there's other issues with the third-party providers in getting the continuity of care, I know there is an authorization that's currently out there for workers' compensation. I believe Marie Gallo Hall stated at a prior meeting, I believe it was in this working group, that the workers' compensation committee is working on a new, more HIPAA compliant authorization. So that will solve that problem and doesn't have to be done by this working group. They're updating that authorization. I think folks are looking forward to that. But if there's an issue to help get the reports quicker that you guys identify with your timeline, if you can let us know so we can solve that problem and adjust the statute appropriately. I know one of the things that had been talked about was even something on the statute if we wanted to have, you know, a clarification for workers' compensation as to where to send the records request. That might be something that solves the problem. I think people who practice comp have figured out where to send the records request, but I think folks who might do a little bit of comp probably have difficulty knowing when do you go to the chart swap versus the email at this location versus the snail mail at the doctor's office, to get those requests and make sure the authorizations are where they need to be for timely request and production. And the other thing I was just thinking out loud is to mention, you know, maybe the first penalty should be a letter from the commissioner. You know, before you go to a fee or a fine is a letter. That might get folks to have a conversation or to solve the problem. And then the penalty or the penalty could get a little stronger within the commission's due consideration or due cause. Just to have, okay, you know, because we have the no-show letters in workers' compensation. If someone, you know, if respondents miss a hearing, usually it's because the insurance company doesn't know where to go. The hearing notice didn't get to the right place. The first step of the penalty is just a letter saying, hey, you were supposed to be here, or hey, you were supposed to do this. And that usually solves the problem, because once people are on notice, they tend to solve the problem before they get fines or penalties. So I don't think we need, you know, to go right to the fines or penalties. We can do something as to, hey, you know, it's been noticed that there's a problem with getting the record to the right location, and hopefully that would sort it out.
Thanks, Rep. Conley. Marie?
Yeah, Chris, you know, I don't disagree with you that clearly this is a real problem, and certainly we would like to have it resolved as well. I am concerned with your suggestion that letters start going out from the commission all the time, because it would be all the time, and that might be a lot for us.
So it might be, good point, Marie. It might be after a hearing, if it's raised at a hearing, to limit it, not just to the commission, so that it doesn't overflow the commission.
All right. Anything else that anybody would like to add on the workers' comp aspect that we've been talking about this morning? Okay. Anything on the other issues that we've been discussing that anyone would like to bring up? I will say we did send along some attachments that we had received last evening from the third-party provider folks with some statistics that I'd encourage you all to take a look at. We can certainly have a discussion on those next week, or excuse me, in 2 weeks. Anything else though? Go ahead, Mike.
So I had just sent around an edited proposal that no one's probably had a chance to look at because it probably only arrived at the beginning of today's meeting. But there were only 2 minor edits that I made to the last proposal that I submitted. One was Kyle had made the suggestion in his proposal that we use the term business associate as opposed to someone in possession or control. And this was an issue that Jennifer had addressed as well in one of our earlier meetings. So I eliminated the phrasing that I previously had about person in possession or control, and instead substituted the word business associate because it's something that's defined already for us under federal law and has been interpreted, and so we can rely on that. It seems to make more sense to me. The only other thing that I did was deal with the timing of the request issue. Kyle had made a proposal about the timing of the request. Essentially, when does the 30 days start to tick? And so I added a provision about when the 30 days would start to tick if it was electronically conveyed by email or fax. I had indicated that the date of receipt would be the day it was emailed or faxed. And I don't have it immediately in front of me, but for if it was mailed, then I provided a certain number of days. I think it was, if I'm not mistaken, 2 days. I can't recall for sure. But those were the only 2 changes that I made to the statute, and that was really based on some of the commentary at the last meeting and one of the earlier meetings from Jennifer and Kyle.
Okay. All right. Thanks, Mike. Anyone else? Okay. Then for our next meeting on January 16th, we'll discuss the proposal with the edits that Mike D'Amico sent around, and we'll also discuss the documents that the third-party providers have sent around, and we'll go from there. I'd also, for the next meeting, we'll attempt to have an edited version of the workers' compensation statute 31294F, but we'll hold off on doing that until we've received some of the information that Kyle had talked about getting us, and we'll go from there. So if there is nothing else, again, our next meeting will be on Tuesday, January 16th at 10 o'clock here on Zoom. And again, if there is nothing else, if I could have a motion to adjourn.
So moved.
Second. Rep. Conley, thank you. All in favor?
Aye.
Okay. Again, thank you all very much. Happy New Year, and we'll see you back in a couple of weeks.
All right. Thank you. Happy New Year to you.
Thank you.